Thank you for attending Reading the Tea Leaves, the Future of Marijuana Rescheduling. The event is hosted by the Drug Enforcement and Policy Center at The Ohio State University Moritz College of Law. Before we begin, we have just a few notes we'd like to share with you. First, we want to draw your attention to the Q&A function at the bottom of the Zoom window. The chat is disabled, but you may submit questions at any time. Please note, however, that there is limited time available for Q&A during the webinar. Second, automatic closed captioning has been enabled for the event. To change how you view the transcription or to hide it, click Show Caption in the menu at the bottom of your Zoom window. Finally, this event is being recorded. The recording will be made available on our YouTube channel as soon as possible following the event. A link will be shared with all registrants via email as soon as it is available. Follow us at OSU Law DEPC to stay up to date on our research, programming, and future events. Thank you again for joining us, and we hope you enjoy the discussion. Bridget?
Hello. Welcome. Thank you, Holly, for convening us. I'm so pleased to be here today with all of you to check in on the status of marijuana rescheduling. Thank you to the OSU DEPIC crew for inviting me to be part of this event. It's wonderful to have you on campus, and it's a joy to be your colleagues. Okay, so if you're tuning into this webinar, you are likely very aware that in October 22, President Biden directed the Secretary of HHS and the Attorney General to begin a process to review how marijuana is scheduled under federal law. Now, certain drugs and other substances are on various schedules. Schedules are a term of art, and those schedules determine aspects of how those substances are regulated. Now, marijuana is currently listed on Schedule 1, which is the most restrictive schedule, designed to be those substances with, quote, high abuse potential and no accepted medical use. And Schedule 1 drugs cannot be prescribed, dispensed, or administered. Now, Congress has the ability to place drugs on different schedules, so it's important to remember that rescheduling doesn't always need to be done within the executive branch. Congress could do it on its own. But Biden's order sparked a multi-step formal rulemaking process that's ongoing. Now, I wrote a little bit about this process when I took a look at how another drug, methadone, is scheduled. And as Matt will explain, the executive branch has the legal authority to reschedule drugs, but it also has steps that it needs to follow when it does it on its own. And some of those steps have been taken by now for marijuana, but not all of them. So we're here today to check in on the progress of Biden's order. And obviously, we have a different president now. Sometimes executive orders cross over from one administration to the next and continue to be enforced, and sometimes they don't. Now, to work through where things stand, I'm so pleased to have three experts join me to talk this out. Our first is Kat Packer, distinguished cannabis policy practitioner in residence here at Ohio State. She also comes by that position by way of her impressive career in this space, including roles with the Drug Policy Alliance and the City of Los Angeles. Matt Lawrence joins us from Emory, where he's a law professor and a scholar extraordinaire, as well as a former senior advisor to DEA, part of the Department of Justice. And then, of course, my OSU colleague, Patricia Zettler, the John W. Bricker Professor of Law here at Ohio State Moritz College of Law, and just back from time serving as Deputy General Counsel to HHS. So we'll have some discussion on this panel, but I want you to feel free to add questions into the Q&A window. We'll try to work in some responses to your questions along the way, and we'll hold some time at the end for your questions too. Okay, let's just jump right into it. Now, Matt, could you start us off by telling us more about the process for administrative rescheduling of substances in general and DEA's role in particular?
Yeah, thank you, Bridget. Happy to jump in. I'll say thank you to you and the Drug Enforcement and Policy Center. You all, any of you joining from Ohio or Ohio State, you have such a gem. It's a national kind of leader in this space that you have there. I also want to say that I'm sharing my own opinions and views and not those of current or former employers. So then I'll jump in. So let me start like right at the top. We have a system of checks and balances under which normally Congress makes the laws, the president enforces the laws, and the courts adjudicate disputes. And so the normal thing under our Constitution would be Congress would make decisions about like banning marijuana or not. And that would be done by our representatives and our senators through law. But very often in the administrative state, what we do is Congress passes a law that gives some agency under the president power to make those choices themselves. So instead of doing it the kind of constitutional default way of Congress writes a law that says marijuana is banned, marijuana is not, Congress writes a law that tells an agency like the Department of Justice, that's what the Controlled Substances Act does. Congress writes a law and says, Department of Justice, you working with HHS, which Patty will talk about, you make decisions about drug scheduling, what's banned and what's not. And then in the Controlled Substances Act, Congress said, and you have to follow these very specific rules for how you get to make those decisions. You can't just wake up in the morning and tweet, marijuana is banned now, and it becomes banned. You have to follow very complicated steps. And so now I'll describe what those steps are, but I just want to reiterate, those are steps set forth in laws that we, the people, wrote through our representatives in Congress. And so the administrative officials are kind of doing their best to work through the instructions we gave them. So what are the rules? I'll try to be quick, but the process for the agencies to change the schedule for a drug, to unban it or ban it or allow medical use or those types of things, requires the agency to choose from a menu of 5 regulatory packages, which are schedules, and schedule 1, 2, 3, 4, 5. And the agency has to go through a really long checklist to make that choice. So first, there has to be views sought from HHS about the kind of medical and scientific questions. And I'll leave it to Patty to talk a little bit more about that. But HHS, the Department of Health and Human Services, that's currently headed by RFK Jr. That agency has to provide medical and scientific kind of advice that's binding in some ways to the Department of Justice, to the Attorney General. The Attorney General, that's currently Pam Bondi, the Attorney General has said, just like Congress said to the Attorney General, hey, we're not going to decide ourselves about marijuana. We want you to do it. The Attorney General has said to DEA, Congress asked me to decide this, but I would like you, DEA, to decide this for me. And that happened in the 70s. So then DEA gets HHS's advice, and it has to go through a process where first it issues a notice of proposed rulemaking, where it tells everybody I'm thinking about rescheduling. It seeks comments about views from anywhere in the nation. It's required by the statute to do what's called formal rulemaking, which is almost like trial-like. There has to be like a hearing. And so then after comments are received from all across the nation, the agency has to have a hearing officer appointed, an ALJ. That's Judge Mulrooney, who's overseeing this proceeding right now. And then the ALJ has to work with the agency and the parties to identify witnesses, to set up cross-examination, to do pre-hearing procedures, and then ultimately to hold a hearing where it's like Law and Order or something. There's people in a courtroom and they're getting up and they're presenting witnesses, cross-examining the witnesses. The decision in the courtroom is, of course, not is marijuana guilty or innocent or something like that. It's does marijuana fit these very elaborate questions that go to currently accepted medical use and risk and things like that. And then ultimately there'd be a set of findings from that hearing. And then that hearing decision would then go to the Attorney General or on delegation to DEA. And DEA, the DEA administrator would issue a final scheduling decision, either saying, yes, I'm rescheduling, or no, I'm not, which is another way of saying, yes, I'm shifting it to a different option I have where you can have medical use, when you can't now or something like that. And then finally, once that decision is reached, the statute says if people are upset by the decision, they can appeal directly to a circuit court. And they can go to a circuit court of appeals and say the agency messed up the law, the agency messed up the facts. That's happened a lot over the years with scheduling actions. And that potential appeal is kind of the last step once we get the ruling from the agency. So that's my best 5-minute overview of the process here.
Okay, well, I'm exhausted already. That is much more involved than a lot of the ways that other agencies make rules. So when Congress gave these agencies the ability to change the way drugs are scheduled, they set up this elaborate series of hurdles that the agencies have to go through. Matt, just before we move on to Patty to talk about HHS, is there anything else that you'd point out about the specific role of DEA in this process? I mean, that's where this formal rulemaking process happens, is at DEA. Is that right?
Yeah, I would say that in the Controlled Substances Act, the DEA is not mentioned. They didn't exist. So when we, the people, wrote the rules, DEA was maybe a twinkle in our eye. But then what's happened since the early 70s is DEA was created, and the kind of authority for all of this within the Attorney General's office, within the Department of Justice, was delegated to DEA. So there's a regulation, I won't give the exact site, where it says all of this power that the people wrote goes to the Department of Justice, your Attorney General, that's going to go to the DEA and the DEA administrator, and there it has sat for 50 years. So if you go read a typical blog post, let's say explaining the process, it explains the process as it's kind of operated for the last 50 years, rather than necessarily the one in the statute. And the one as it operates is that DEA is running the whole show. Now there have been, it's important to make this distinction because it's going to come up later in our talk, I think, some of these differences.
Yeah, no, totally. Okay, so let's get Patty into the mix here, and so round out for us the role that HHS plays in this process.
Yeah, so first of all, thank you everyone for being here. Thank you, Bridget, for that kind introduction. And big thanks to Matt and Kat for participating. That was a great introduction to formal rulemaking, and I wish I had recorded it so I could play it for my law students when I teach about these processes in class. But as Matt mentioned, ultimately, when we're talking about the administrative scheduling process, it is DEA's decision about how to schedule a substance. But when we, the people, wrote the Controlled Substances Act, HHS was given a significant role. So under the Controlled Substances Act, before DEA initiates proceedings to schedule, reschedule, or totally deschedule a substance, the law requires DEA to request from HHS, the Department of Health and Human Services, a scientific and medical evaluation of the substance and a recommendation about what schedule, if any, the substance should be placed in. And the idea there is that scheduling is not just a law enforcement question. So why Congress wrote the law this way is that scheduling is not just a law enforcement question. It also involves these questions of science and medicine about what the substance actually is, how does it pharmacologically operate, what risks does it pose to individuals and the public health, and so on. So this is the sort of compromise in the CSA about how to balance those medical and scientific questions and the law enforcement questions associated with scheduling. So DEA requests that evaluation from HHS and that recommendation, and then HHS does its thing. There are, factors in the statute that HHS is required to consider, and ultimately, as happened here in August 2023, HHS communicates a recommendation to DEA about what schedule a substance should be placed in and explains its medical and scientific determinations. Here, HHS recommended that marijuana be placed in Schedule 3. I see a question in the chat about currently accepted medical use, and I think we'll get to that later. But in terms of just understanding the process, HHS's scientific and medical determinations are binding on DEA when it proposes to schedule, reschedule, or deschedule a substance. And then they're owed significant deference from DEA at the point when DEA is finalizing its decision. So this recognizes that the HHS recommendation comes before a proposal, and as Matt talked about, there's all this opportunity for public input after the proposal, both comments on the proposal, at a hearing, et cetera. So DEA's ultimate decision has to incorporate that part of the process as well. So again, it's ultimately DEA's decision, though HHS plays a strong role. The one exception to that is if HHS recommends that a substance not be scheduled at all, then DEA is prohibited from scheduling it. But here we're not in that bucket.
Okay, so that's a great starter pack on how this process works in general. Kat, is there anything that you want to add to the sort of formal process as we understand it? And then we'll get into the specifics of how it's working on marijuana.
Yeah, just to add that there are a number of circumstances in this particular rescheduling decision that were kind of out of the ordinary, and I'm sure we'll get into that. But in part, it being the the Department of Justice that actually issued the proposed rule and new tests for currently accepted medical use. So I know we'll get into that a little bit later. But just to say there is this complex process, and thank you, Matt, for describing it in such a concise way. You did it in 4 minutes. I often try doing like 45 minutes. But there were some deviations from the standard process in this particular rulemaking.
Okay, so let's get into that then. Let's talk about how this has been working for marijuana in particular. So Biden in 2022 sort of sets the agencies down this path. So Matt, where are we in the process for marijuana? Basically, what's happened so far?
Yeah, I'll say I can tell what has happened so far from public reporting and the public docket items. I actually have no insight. I did not work on marijuana scheduling when I was with DEA, but I can describe what's kind of out there in public. So I said how the process starts where there's a HHS shares views, and then from the Department of Justice or DEA, and we'll talk more about that in a second, there is a notice of proposed rulemaking to begin the process. And what happened this past year was very interesting. The agency, the Department of Justice put out a notice of proposed rulemaking to reschedule marijuana to Schedule 3, to shift it from Schedule 1 to Schedule 3, and this is a proposal. And so then, of course, the headlines are all like, DEA is rescheduling marijuana and that kind of thing. But if you really look closely, there were a couple of interesting things that happened at that time. First, the Department of Justice's Office of Legal Counsel, which is it's like legally authoritative. When there's a dispute between agencies about what the law means, like if I dispute what the law means with an agency, I go to court. But if two agencies are fighting about what the law means, usually they don't go to court. Instead, they go to the Office of Legal Counsel. And we get the indication of that from the Office of Legal Counsel at the Department of Justice, which is, it says DEA has said that this particular term in the statute, currently accepted medical use, does marijuana have a currently accepted medical use? DEA says it means a certain thing, which we could talk more about, which is fairly hard to do, or really hard to do. And then HHS, Department of Health and Human Services, says actually what that means in the statute is more, it's still tough, very tough, but it's not quite as tough. And what the Office of Legal Counsel said is, we actually think that HHS is getting the law right on that. That's the first thing that was interesting. What that shows you is that, for often I think we say DEA does scheduling, because that's the way it normally happens. But under the statute, it's the Attorney General who has the authority. The Attorney General has subdelegated it to the agency, and which is DEA. So like normally it is DEA, but technically speaking, it's the Attorney General's power, right? And then like on this legal question, DEA did not have the last word. Instead, it was the Office of Legal Counsel who works for the Attorney General that had the last word. And I don't know if my hand motions are making any sense, but you get to see the kind of, it forces you to kind of look inside what's happening. And then the second thing that was interesting is if you look at the notice that came out proposing to reschedule, in the past, if you look at notices, it says the Drug Enforcement Administration is rescheduling, the Drug Enforcement Administration. And this one was the Attorney General exercising the authority. So at least as an outside observer, at that time I was reading that and I was thinking, maybe this is an indication. And Dave Posen has a blog post on balkanization, I think called Reading the Tea Leaves. And then there was subsequent reporting on this that kind of says, well, this actually looks like that fact that the statute gives the power to the Attorney General, and the Attorney General normally relies on the DEA, that might actually be relevant, because maybe here the DEA, for whatever reason, or the Attorney General had to let, it was the Attorney General who did it, who started that process. So that's what happened to start the process. And then that history, I'll say quickly, has followed us, because then that notice comes out and starts the process, and then DEA faithfully begins implementing the process. We get DEA collecting comments, and then they appoint Judge Mulrooney, and they start picking hearing participants. DEA comes to a list of 25 hearing participants. They're in pre-hearing procedures to say, how are we going to, what are we doing? What are this? And then disputes emerged. Many participants had wanted to participate and were not listed on DEA's list of 25. Okay. And parties that were frustrated that they were included wind up going to Judge Mulrooney, and they say, hey, we were excluded because DEA is biased. It's trying to stack the deck or load the dice against rescheduling. So this is people, filing motions with Judge Mulrooney. I don't know if this is true. I'm just saying what they file in the motions. they file motions with Judge Mulrooney saying, DEA has stacked the deck against rescheduling. And of course, the government DEA comes back and says, no, we haven't, And then they also filed a motion with Judge Mulrooney that says DEA, they allege the DEA talked to or had some kind of ex parte communication with witnesses. And that's a problem. And again, the DEA attorneys file, opposition that says, no, that's not true. And then that gets you to, before the hearing was ever held in January, Judge Mulrooney takes those motions. And remember, it's frustrated participants saying the DEA stacked the deck against it, and it's had ex parte communications, and then the government saying, no, no, no. Judge Mulrooney ruled against those motions. So he said, I'm denying these motions that are alleging problems. It was a motion to supplement the record. I'm denying that. So Judge Mulrooney denies it. But he says, given all this controversy, I'm now going to postpone the hearing and allow the parties to now appeal my ruling up if they want to go complain to the DEA administrator about my ruling denying this motion. And then also simultaneously, there have now been a couple of lawsuits filed in federal court by people saying, hey, this is a problem. So that the status quo as of today is we were proceeding towards this hearing, but then these questions emerged about DEA's perspective and how it relates to the hearing. And that's led to this denied motion, but along with it, a canceled hearing, a potential interlocutory appeal within the DEA. And then also we now have some federal lawsuits out there about the process. So the bottom line of all of that is things have kind of stalled out fighting about process within or before the DEA hearing.
Okay, got it. So we are sort of in this interregnum between, seeing HHS did its part, right? HHS made its recommendation to DEA. The process started to move, and now we're on pause. Patty, is there anything else that you want to add from your perspective about sort of how the process has worked to date?
I guess I'm going to weigh in a little bit on the OLC opinion and currently accepted medical use and try to answer a couple of questions in the chat here on that on that question. So, in the chat, someone's asked how vulnerable this new interpretation of what currently accepted medical use means that HHS used in providing its recommendation to DEA that marijuana be moved to Schedule 3. So as Matt mentioned, when two agencies disagree about how to interpret the law, OLC is generally the decider, the Office of Legal Counsel. So here, there's this specific term in the Controlled Substances Act, currently accepted medical use. And so the dispute is about, or the question is about, what does that term as used in the statute mean? And historically, DEA has generally found, and the reason that matters is because something can be in Schedule 1 or can be moved out of Schedule 1 only if it has a currently accepted medical use. So this is a key criterion for deciding whether it's permissible to transfer marijuana out of Schedule 1. And historically, DEA has used two different tests to determine whether something has a currently accepted medical use. Either the substance is FDA approved, then it's got a currently accepted medical use, or it satisfies this 5-part test that, we don't need to go into the weeds of, but largely aligns with kind of the high expectations we have for drug approval. So then in 2023, when HHS is providing its recommendation to DEA, HHS, as the comments noted, and as Matt noted, used a different 2-part test. So HHS asked whether licensed healthcare providers have widespread current experience with medical use of the drug in accordance with implemented state authorized programs, where the medical use is recognized by entities that regulate the practice of medicine. And the second part of the test is that HHS then asked whether there is some credible scientific support for at least one of those uses, which is a much lower standard than drug approval in terms of sort of the scientific evidence we'd expect. But you can understand why we might have evolved in our thinking about what currently accepted medical use could possibly mean, given the widespread state markets there are today that I know Kat will talk about. But given these differing views of the statute, OLC stepped in, and OLC, as Matt said, agreed with HHS that the 2-part test that HHS used was a permissible read of what currently accepted medical use means in the statute. So DEA is bound by that for now. That doesn't mean another party couldn't challenge that interpretation if they had standing. And then, then I think we might get into questions of what all of the changes in administrative law doctrine might mean for how we interpret this particular provision. So I do think there probably are questions about what would happen if another party challenged that interpretation. But just to sort of give a little more context to the OLC opinion.
Yeah, that's really helpful. Kat, are there particular elements of the process as it's worked to date that you want to comment on?
Yeah, I think part of a lot of the discussion thus far has been on determinations of currently accepted medical use. And I just want to use this as an opportunity to remind folks that, particularly folks who are proponents of rescheduling, is that there are other determinations specifically related to marijuana's abuse potential that are still kind of yet to be determined. And because of this disagreement between agencies, specifically HHS and DEA, on what's binding, what scientific and medical matters are binding, and when, and in particular, the role that DEA played in the process. I'm still convinced that the DEA is likely to argue that marijuana has a high potential for abuse. I say that in part because, as Matt mentioned, it's normally, traditionally, the DEA that plays a role in issuing the proposed rule. And as I spent lots of time looking at the proposed rule itself, I identified that the only role that the DEA played in the actual proposed rule itself, like there's language in the proposed rule that specifically says that DEA has not yet made a determination. But what they do in the proposed rule is note a bunch of specific areas that they would like additional information. And if you zoom in on those specific areas in which they say that they want additional information, it's kind of clear that what they're looking for is evidence to demonstrate marijuana's abuse potential. And I think that there's a through line with the witnesses that were selected by the DEA to specifically support that evidence that DEA called out that it would need additional information on in the proposed rulemaking process. And so I know that it seemed as though it would come as a surprise to some folks later on in the process that the DEA might not be championing this rule. But as soon as, I think early on, when I had identified all of these different pieces of specific additional information that the DEA was requesting, it makes pretty clear that they wouldn't request this information unless they were trying to make sure that they had evidence specifically around marijuana's abuse potential. So I just kind of note that to say, in this process that's still unresolved and ongoing, Schedule 2 is still a possibility because there's this possibility that there are concessions, for example, that marijuana does have a currently accepted medical use, but then there's still a fight and deference. Like, we give significant deference to HHS for its scientific and medical determinations. There's complete deference kind of given to DOJ in matters of abuse because those are considered to be law enforcement matters. And these scheduling decisions, as Patty mentioned, aren't just about scientific and medical matters, but law enforcement matters as well.
I will add one clarifying point, and Matt should jump in if I'm wrong here, but my understanding is actually it probably would be difficult for DEA to differ from HHS's currently accepted medical use recommendation, but DEA is bound by OLC's opinion that it's a permissible read of the statute, and DEA is bound by the scientific and medical determinations that underlie HHS's recommendation that there is a currently accepted medical use, but I don't think it's bound by the ultimate recommendation that statutory criterion is satisfied. So depending on what you think of DEA and how creative they may get to advance a particular policy goal, that may not that may also be not entirely settled either.
And I would just add on that that DEA, kind of under normal executive branch functioning, DEA would be bound by the OLC opinion, but there's precedent in the past for a new administration to come in, and then its OLC might issue a different opinion or disagree. I noticed one of the comments brings up the Act v. DEA case and some of the judicial precedent on what currently accepted medical use is, and it is, if we were, when we get to predicting the future, it's not implausible to imagine that you could see the new administration's OLC revisit the opinion that was issued, and then DEA would no longer be bound by that determination on currently accepted medical use. And then I'll actually use that to add in another comment asked about Chevron. Time was, if there was an ambiguous statutory question, courts would defer to an agency's judgment, but that is no longer. The Supreme Court last summer said that they would not defer. And so it's, when we get to predicting the future, whatever OLC says or DEA says about what currently accepted medical use is, the position of the courts would now be that there is one best meaning of that term. And so if the meaning adopted by the agency is too strict, then that would be something that would be kind of readily subject to challenge in court now, whereas 2 years ago, it would have been a lot harder to challenge an overly strict agency interpretation, and potentially so too an overly lax interpretation.
Okay, great. I feel like we've really gotten to the middle of the tea leaf reading portion of today's program, which makes me happy. I brought my tea, by the way. So just to follow up on something that Kat raised, so Schedule 1 has within it this idea of substances that have a high abuse potential with no accepted medical use. That's right there in, the category for Schedule 1. And what you were seeing in the proposed rule, and then you're saying in the witnesses that, DEA put forward for the hearing, that that to you signaled that DEA was focused on that question of high abuse potential. But we wouldn't expect them not to be. It's right there in Schedule 1, right? So could you say a little bit more about what that tells you about the way DEA is approaching this question? Because since it's an element of Schedule 1, of course they have to pay attention to that element of it, right? One thing that I've never understood in this space, and part of what I study is sort of bureaucratic food fights and like interagency drama. So I'm so here for all of this. But the idea that it's only, DEA focuses on that part, the high abuse potential, and HHS focuses on the sort of medical use side, ignores the possibility that both agencies could sort of have a view on both elements of that, right? So help me understand the kind of your perspective and how you're reading those tea leaves and deciding what to weigh.
Yeah, I think part of it is just looking specifically at the OLC memo. There's a footnote in there that specifically kind of describes this tension around scientific and medical matters versus law enforcement matters. And unfortunately, I don't know that this record helps us, but it clarifies that when Congress was passing the CSA back in the day, it deferred to the DOJ on matters of law enforcement in relation to scheduling. So there are a few factors, 8 factors in total that agencies are considering, but 3 of those factors, I believe, specifically use the word abuse in them. And in this OLC memo, it kind of calls out those specific factors as areas where law enforcement is the primary concern. Now, I think as a fundamental kind of issue, the Department of Justice and the scheduling apparatus consider all non-medically prescribed use to be abuse. And so even the medical use that is happening at the state level that HHS relied on to make its determination of currently accepted medical use is illegal at the federal level, and subsequently counts as, and the DEA considers that use, both medical use and adult use, to be abuse. And so I think that, in hindsight, I think I would have preferred HHS to both tackle redefining currently accepted medical use and trying to kind of reassess and modernize today's definition of abuse. But I think that the scheduling apparatus gives too much deference to law enforcement for issues that should be primarily medical and scientific in nature. But because of that, I think that there will continue to be this fight over whether or not this new test and kind of pass or fail meets this definition of currently accepted medical use, but a much more discretionary decision on what constitutes abuse that is highly deferential, if not within the whole reins of the DEA.
Okay, thank you. That's really helpful. And I think that the interagency dynamics here are so interesting. Now, this is not the only area of law or policy where, a couple of agencies are interested in similar programs, right? There's lots of areas where there's jurisdictional overlap between federal agencies. And what's interesting is sort of how challenging this area is. In other areas, for example, you see much more sort of a joint mission and sort of both working together towards the same goal. Whereas here, it really, it seems quite separate and in a very different posture from sort of from it seeming like it's a collaboration between agencies and more about sort of which agency is going to sort of have its views vindicated. So it just sets things up to be fairly fraught, which is what you could see as we get into this. Patty or Matt, anything that you want to add on this, and then we'll go to Kat to talk about what kind of comments we saw from the proposed rule that came out.
I would just add quickly, Bridget, that the point you just made about maybe whether it's tension between HHS and DEA or something, it's to some extent it's inherent in the statute. I mean, the very first section of the Controlled Substances Act says that a lot of these substances are essential to promote the health and general welfare of Americans. And then second sentence is, but these same substances pose risks. And Congress chose, and this is, this goes back to Congress chose to assign kind of one agency to focus largely but not entirely on the benefits side, and then another agency to focus largely but not entirely on the costs. And to some extent, the agencies are faithfully executing their role in this statute. Now, we could talk about whether the statute is flawed, and I think anyway, we could talk about that. But to some extent, they're faithfully exercising their role in the statute to kind of take the positions, and kind of focus on the interest that they focus on.
I will add quickly, I think this dynamic between HHS and DEA is not limited to marijuana or even to scheduling decisions. And part of that comes from having just very different missions, right? So when HHS works with FTC, for example, or FDA works with FTC, they both have consumer protection missions, although they're somewhat different. So their missions are already pointing them in similar directions, whereas I just think it's not the same. Even though FDA does have criminal investigators and there are criminal penalties available under FDA statute, it's not primarily a law enforcement agency in the same way.
And I'm going to slip in one more tiny thing, which is this to me, I will say this is just my own view. And I have an article with Dave Posen kind of talking about some of this, but this is a reason we want DEA, or Congress maybe wanted DEA to be focused on law enforcement and wants HHS to be focused on access. And that's one reason that the CSA makes sense, that it's the Attorney General that makes the actual scheduling decision, because they could be above that, right? And you could have voices before you advocating vigorously opposing sides, and then the Attorney General can resolve. That's one reason I think that the Attorney General's role in the initiation of rescheduling was totally appropriate and kind of fits within the statutory scheme. But anyway, so I'll just slip that in.
No, I appreciate that. And I appreciate the way that we are keeping Congress in this conversation, right? I think particularly because we're like way down deep in a bureaucratic rescheduling process, we can sort of lose sight of the role of Congress in all of this. And so I appreciate us like remembering that this was the statutory scheme that Congress created, and we can be unhappy with that, right? But that unhappiness, needs to be delivered to Congress rather than, we're kind of stuck with the process that we've got, right? Okay, so Kat, so tell us, so there's proposed rule came out, I know you took some time to look closely at the comments that came in. So just tell us a little bit about what you found when you took a look at the comments that came in.
Yeah,